the National Endowment for Liberty presents At Issue, the in-depth forum on freedom in America today. Hello, I'm Mike Hayes. The host of At Issue is the physician, author, and former member of Congress, Ron Paul. Ron?
Thanks, Mike. If you've ever served on a jury, you've participated in one of the few times in which ordinary citizens wield real power in our political system. But chances are nobody bothered to tell you how much power you really had. In today's program, we'll tell you some things judges and lawyers don't want you to know.
Our program, as usual, will consist of our probe report on what's at issue, reactions from a group of average citizens somewhere in the country, and an in-depth analysis of the entire subject by our panel of experts. We'll begin our probe report, Power to the Jury, following this brief message. A typical American courtroom. Here, day after day, week after week, the laws and the people of our nation meet face to face. In any individual case, it is a virtual certainty that the law was not passed with these precise circumstances in mind. It was passed by a busy legislature with 1,000 other things on its agenda and its mind. It won its passage most probably because a majority of the legislators thought it fit their ideological agenda, or would enhance their re-election chances, or was requested by a special interest to which they owed a favor. In most cases, they never even read the actual bill itself. Legislators are government employees, and so is the judge who presides in this room. In the whole process, there are only 2 points at which ordinary citizens get to make decisions. One is in the voting booth, and the other is here, in the jury box. Here, ordinary men and women make decisions on whether or not to take a person's property, liberty, even his life. They have the power to judge the facts of the case at hand. And when they want to exercise it, they also have the inherent power to judge the worthiness of the law itself.
In a criminal case, when the jury goes back and closes the door, they are a power unto themselves. They can do what they feel is right, notwithstanding what the instructions are. It is what 12 minds determine should be the appropriate verdict in that particular case.
These principles date back centuries. A famous case involved the Quaker leader William Penn.
William Penn, I guess, was where it all started. He was out preaching in the streets, got arrested for it. This was back in 1670. And even though it was very clear that he had been doing what was against the law at that time, preaching on the streets, the jury refused to convict him. The reaction of the judge was to send 4 of the jurors to jail because they hadn't followed his instructions. But a higher court overruled that and said that juries had the right to judge both the facts and the law. And that was really the beginning of the idea of jury nullification in British law, and then it came into American law.
The Penn jurors struck a blow for religious freedom. In the colonial United States, it was a case involving freedom of the press, which helped establish the right of juries to nullify bad laws.
A lot of journalists are familiar with the Peter Zenger case. What they may not realize is that was essentially a case of jury nullification. The jury ignored the instructions of the judge. And again, a very important precedent was set.
Half a century later, America's founding fathers recognized the importance of juries to the functioning of a free country. Jefferson called trial by jury the only anchor ever imagined by man by which a government can be held to the principles of its Constitution.
Up until about the middle of the 19th century, it was standard practice in this country for judges to instruct lawyers and for lawyers to instruct the juries on their right to judge both the law and the facts. And people such as the first Chief Justice, John Jay, Thomas Jefferson, and a panoply of famous legal scholars through American history have supported the concept.
Today, judges almost never instruct juries that they have the right to judge the law as well as the facts.
We've always tried to rely on the jury system, but jurors have a innate sense of what's right and what's wrong. That always seems to come through during a trial. But when they go back to the jury room, if a juror receives an instruction of law telling them that they have to follow the law, and they don't like the law, many jurors feel honor-bound to do that.
Concern about the dwindling power of juries has resulted in the birth of a citizens' campaign to bring about a change in the way judges instruct juries.
We're real careful to inform defendants of their rights. You have the right to remain silent. Anything you say may be used against you, know, all that stuff. We all know Miranda's by heart. We've seen it on television 2,000 times. Right? But they don't read the jury its rights, do they? And the jury has plenty of rights. And one of the most important ones is to decide whether the law is just.
Most jurisdictions in this country today, if an attorney stands up and starts making arguments, telling juries that you have the right to go back and decide as to what you can do and what you can't do. You're a power unto yourself. Start to give the classic jury nullification argument. A judge would stop you as soon as he sensed that was happening, tell the jury to disregard it, sanction the lawyer, and tell the lawyer would be held in contempt of court if he continued arguing along those lines. So there's a very thin line that one has to walk when trying to talk to a jury about jury nullification.
But today you are the law. You are the law. Not some book, not the lawyers, not a marble statue or the trappings of the court. See, those are just symbols of our desire to be just. If we are to have faith in justice, we need only to believe in ourselves and act with justice. See, I believe there is justice in our hearts.
In the movies, dramatic moments and happy endings abound. But preserving the rights of juries is important in real life, too. 12 honest people with justice in their hearts sitting in these chairs are the citizenry's ultimate defense against bad laws, corrupt officials, and government tyranny, all of which we surely have today, though we may disagree on exactly how much. Regardless, we cannot afford to see the power of the jury further eroded through design, neglect, or apathy. Sooner or later, the day will come when it will be needed desperately.
My jury experience, without anybody really talking about it, the jury began to get a sense of what was just in this. And you know, let's not find this guy guilty or not guilty based on the law. Let's find him guilty or not guilty based on whether we really think he should do the time.
Each week on At Issue, we show the probe report you've just seen to a group of citizens somewhere in the United States. What you're watching are the unrehearsed reactions of people in Tampa, Florida, to the probe report, Power to the Jury.
Lawyers were surprised because they didn't think we'd go this way at all. But after talking about it over a length of time, we realized that the guy had obviously broken the law, but he hadn't broken the law, we felt, in our hearts to the point of doing this longer sentence.
When it came to the decision, what we had with the law that they gave us, we had to make the decision according to that law, and I really was disappointed because I felt that justice was not served because the law did not fit the crime.
Okay, if you had been told at the point you got ready to go into that jury room that if you don't think the law fits in this case, you have the right to make the decision based on the fact that the law doesn't fit, do you think it would have impacted the difference, would have made a difference?
Yes, yes, I really do.
If someone's brought to trial and what the law says is one thing, but what you feel and you can convey to the jury, in that room, if it's a bad law, then I think it's up to you, and you know it's a bad law, to express your opinion and state why, and then if the other people agree, then go from there. And then if they disagree, then they need to prove it to you.
Governments can make anything illegal, and that's the sad thing about other countries. And if you have juries that can reject the laws, and you have the ability to prevent the type of bizarre things that happen.
Let's take it one step further, backwards. How did we get into this position?
I almost think that it's because the judges do not feel that 12 ordinary people are capable of making more than a guilty or not guilty choice. I mean, throw that third one in and people will not be able to make a choice. And I think that maybe they just don't trust the jury system as they should, that ordinary people can decide whether someone's guilty, not guilty, or that the law does not apply in this case.
The law is made by, biases, or is it really ethical? Or, I don't think some of the legislators are very ethical, I guess.
Well, I can see how the jury idea here could be used as a tool in the legislative process. In other words, it's like giving feedback to these legislators about what people think about what's going on.
I think before any jury is elected to be a jury, they should see this. I'm serious. That's what I did.
I've never been in a jury, and I think it's great that I saw that because I learned a lot about it.
They actually put in a plug for our show there. Well, let's see how our panel of experts feels about this issue. Dr. Eugene Hickok is a professor at Dickinson College and a resident scholar at the Heritage Foundation. Larry Dodge is the founder of the Fully Informed Jury Amendment Organization. And our host and permanent panelist is the chairman of the National Endowment for Liberty, Ron Paul. Ron, do you agree with the research group that all jurors really ought to see that program?
It certainly sounds like a great idea to me. I think that's a good deal. And I'm going to do everything possible to get as many people to get introduced to this idea, and I'm delighted to have two experts here with whom I can discuss this with. It wasn't too many years ago I was not very much aware of what jury nullification was all about. Matter of fact, I came across a book by Lysander Spooner, Trial by Jury, and I was really enlightened by this. And this fits very well into any individual, including myself, who at times feels very frustrated about big government. I mean, here we try to improve our government. We recently talked about reforming Congress and changing Congress, but what happens? 96, 98, 99% of them get reelected. So those who are unhappy and need something to do in order to change things, I mean, really, this idea, this concept really gives hope to a lot of people. It's a real eye-opener to a lot. It was an eye-opener to me, and I think it's going to be an eye-opener to a lot of people in the general public, not realizing that juries have rights and that they have a responsibility, not just to deal with that particular case, but also a very deep responsibility to judge our judges and to judge our lawmakers. And it's amazing now to me to realize that we went so many years and this was totally neglected. But Larry, I want to start by asking you a specific question. Those who disagree with us, that think that this is too much power for the individual, too much responsibility for the jury, they say, oh, this is going to lead to nothing but chaos. They're going to revoke laws and we'll have anarchy. What's your answer to that concern?
I can't see any possibility of it, Ron. For the first century that we were a nation, it was routine for the court to instruct the jury that you are judges both of law and of fact. And we didn't have any anarchy or chaos then. And matter of fact, we had the government under control of the people, which is the way it's supposed to be.
And government was a lot smaller, of course, at that particular time. It seems like they almost have to have these judges protecting the lawmakers, that they can't expose the jury to too much information in fear that they may rule in a different manner. Gene, as a teacher and professor and someone that's interested in constitutional law, is this an issue that's been of interest to you, and how do you see this fitting into our current events today?
Well, it's kind of a curious turn of events over the last 200 years. If you look at the start of the Republic, as was demonstrated in the piece before we started our discussion. It was very important to those who wrote the